Please be seated.
You may proceed. Oh, not yet.
That means I can say anything I want, right?
Right, exactly. It's not being recorded. You may proceed.
Your Honor, may we vote?
Yeah. I don't know what they want. I don't know what they want. That's fine. That's fine. I'll be good.
Thank you.
You may proceed.
Thank you, Judge.
Judge, objection on the record noted.
Very good. It was so preserved outside the presence of the jury, it'll be argued.
Thank you.
Thank you.
Only as to one portion.
Man, I wonder if anybody who testified other than Mr. Thomas told the truth. According to him. Everybody's alive, except him. In law school, they teach you a lot of stuff, and some of it helpful, some of it not. One of the things that they teach in law school is if you got the facts, you argue the facts. You got the law, you argue the law. If you got neither, you attack your opponent. I think that's what you're seeing here. There's not a single witness that testified that gave Mr. Thomas the record he wanted to argue for. So what did he do? He made stuff up. He misrepresented testimony. And he led the witnesses into saying things that maybe you remember, maybe you don't. So I submit to you, because of that, it shows that the facts aren't with him. How do you figure out whether or not he's doing that or not? Well, one of the ways you do that is he the one testifying or is it the witness? How many times did you hear, who's testifying here? You walk witness through witness, put words in their mouth. They can argue. That's called leading questions. Another way you might do it is to ask pregnant questions, I call it that. Some people don't like it when I do that. Sorry if it offends you. But that's assuming facts that aren't in evidence. Like he asked a question at one point, isn't it true that Mr. Dent was convicted of possession with the intent to deliver cocaine when that's not in evidence and it's not true? To get it out in front of you. That's a pregnant question. What else might you do on this week? You argue things that aren't true and hope the jury buys it. He argued there's no evidence in the medical record that he had a broken nose. Look at page 98. It's there. In opening, he told you that Officer Melendez was ordered out there to do surveillance and that Mr. Dent had cocaine on him. Neither of those things are true. Yet they're in the record out of his mouth. How else might you get your point across? And I went back up a minute. He says, I have a version and the prosecutor has a version. My version don't matter, and neither does his. What matters are the facts that came out of the witness stand and the exhibits. how else might you argue when the facts aren't with you? You pick descriptors, you pick words. To paint a picture that's different than the reality. He keeps calling what Mr. Dent does a struggle. It's combative. That he's fighting. Is that what you see? Or do you see him getting beaten in the head, pulling his hands up to cover himself and trying to get that arm from around his neck? Do you see him pulling his hand away from Mr. Zelenowski so he doesn't go face down in the concrete? I don't see a fight. If it was a fight, it wasn't much of one. So he used descriptors. What else might you do? You might try to get the defendant's version of the facts out without exposing him to cross-examination. Now, I know...
That is impermissible. That is impermissible. He has no obligation to take the witness stand. Any comment on that is unfair.
Let him finish. Go ahead, counsel.
He has every right not to testify. But it's hearsay, his story. Unless he's subject to cross-examination.
I'll allow that. Go ahead.
You know, you had a witness there, Judge.
Counsel, that's to be stricken from record.
He tried and he tried and he tried to get it in, and he finally did. All right, what did he get in? He got in that he bit him. Well, is there really any evidence that he bit him? Kreitzer says he showed me a mark on the arm. I think you see that in the video. Just about the time they're doing the body surfing and you see him throw his head back, you're going to see Melendez in there with the rags and the disinfectant going up and down his arm. Kreitzer's right there. Doesn't lift up his arm. Now, if you really got bit by somebody, don't you think you would clean that off? Don't you think at the scene, you take a look at it, when it all ended? Take a look. He doesn't do that. He goes looking for the dope and he can't find it. That's what he does. He's laughing, or at least it looks like he's laughing back at the precinct when he's talking about it. Some injury. The argument in the trial of this case in some ways is sort of like a magician performance. And what I mean by that is, don't pay attention to the video. Pay attention to the smoke and mirrors over here. His whole argument, how often did he talk about 16 blocks? He wants to divert your attention. The other thing that he's done during the course of this trial is he showed it to you a bunch of times. I submit to you that was a tactic as well. Everybody knows that if you start watching horror flicks with all sorts of blood and gore, after a while you get acclimated to it. I submit to you that's going. He brings in a bunch of movie critics to tell you what you're watching, including him. You know what you're watching, and what you see, and what you don't see. He had Yost, Westrick, bunch of POs, go through the whole thing. And basically, and we'll get back to this in a minute, that reasonable police officer would do everything, except for the key point. He brings an expert in to do the same thing. He says, I see blue lights. Well, you don't see blue lights. Mr. Thomas tried to correct him on that after he testified to it. He doesn't testify at all on direct that he's a police officer. He doesn't mention the fact that he has an affinity for police officers. His son's a police officer, been assaulted in the line of duty, been shot in the line of duty, and that he admits that that can color how he looks at things. And lo and behold, it did. There isn't anything that Mr. Thomas said was on there that he didn't say was on there. And he even added stuff. Blue lights and punches. See any blue lights? See any punches? And everything in between? He talks about all sorts of stuff. Furtive gestures, everything else. Now, they want to say that Mr. Dent ended up going all the way across the car, reaching under the seat, putting the dope under the seat, and you can't see that in the video, can you? And you know you can see through. How do you know you can see through? When Melendez goes in there looking for the dope, when he doesn't find it, you clearly see him going across. Dent never went across. How else do you know that? How far in does the arm of Officer Zelenowski go to yank him out of that far? He's not reaching across. He's not bending in. And you can see his feet on the ground when he's yanking him out. He just pulls him up and down. They also argue, oh, this door opened violently. Should he open the door? Probably not, I think. I think he wouldn't do it again. But that door doesn't even open all the way. The door has two places. It catches in the middle. That's a violent opening of the door. Then he wants to argue the medical records. I invite you to look at the medical records. I want you to look at the medical records. Well, what does he do with them? I submit to you he misleads. The very first page, which is why I asked if that was what was up there, they're saying that the police say he had dope on him. We know that's not true. You go through the medical records over and over and over again, he says, I didn't do any cocaine. It's clear that the cops were in there, two of them at his bedside for the whole time, chiming in and victimizing Mr. Dent.
Judge,
no, there was...
Judge, I'm going to object. There's no evidence about what happened in the hospital with the police officers.
The doctor said that the police officers were given information. Page 1 says the police officers were given information. The records say there was 2 cops in that room. I think you can go with reasonable inference. We know he didn't have dope. The dope's found somewhere. Well, we know it wasn't on him. When he was patted down, he had no dope. And he had no dope in his system. He wants to take a screen, a test for metabolites, an inert substance that can be found in false positives, and say that makes him high. Why does he do that? Because he really wants you to believe he deserved what he got. He's just a dope. He says, oh, he didn't complain about his neck. Look in there. He complains about his neck. The first night, his main complaint is he has a blowout fracture of his eye. He doesn't talk about the injuries. He wants to talk about 2 places where it says he admitted to using dope, one of which starts at the top, polysubstance abuser, and at the bottom says he denies use. You know it's coming from somewhere else. He says this is a chase when they fall in behind him. And then he almost kills people during this chase. I don't think that's what it shows, but that's up to you. Then he suggests he almost got away, almost wreaked havoc on the entire community. Could have got a gun, could have run somebody down, could have. None of it's in evidence. It's possible, I guess. The law is the second thing that you can argue when it's with you. And I submit to you that the law isn't with him. And why do I say that? He keeps talking about with witnesses and with his questions, and his arguments to you, it's okay to step it up. These two pieces of paper say it's okay. It's not okay unless it's reasonable. His own expert said that. And all sorts of governments that do all sorts of terrible things have pieces of paper that say they can do it. Those papers mean nothing. Is it reasonable? He also suggests that I have to prove a whole bunch of stuff that I don't have to prove. He said in opening statement that one of the things that I have to prove is what he was doing out there, being Mr. Dent. I don't have to prove what he was doing out there. I think I did. He wants me to prove a negative. He wasn't on drugs. I think I did that. Have a medical examiner and a toxicologist both say he was not on drugs. We'll get back to it, but they're liars, I guess. Or incompetent. He also says I have to prove that he wasn't at the hotel. I think I did that. Don't have to. There's no car that you could see going into that hotel. There's no car you see coming out of that hotel. There's no car you see turning down the street. None of that. And the phones track Mr. Dent's movements exactly. He wants to argue all the Times. I don't know how many were watching, but when you go back to it, they're not all going to be the same. It's just the way it is. So an argue a 2 or 3 minute differential, I think is stretching. But the proofs support my version of the facts, but it doesn't matter. He thinks it matters. He thinks I have to prove it, but I don't. I have to prove that what Mr. Melendez did was unreasonable. That's what I have to prove. So what's he left with? He's left with attacking his opponent. It's called ad hominem attacks if you go to law school or speak Latin. And he's done it to everybody. He did it to Tawana Powell. She's biased. She's out to get him. She's only looking at one thing. Did it to me. I'm lying to you with a straight face. Did it to the ME. He's making this stuff up. The lab's incompetent. The witness at the apartment complex, she's lying too. The only person who's not lying to you, if you buy this theory, is Mr. Thomas. If he were a witness, I'd love to cross-examine him, but I can't. He's not a witness. He goes after Mr. Dent. Mr. Dent sat here in front of you. You were able to get a flavor for who this man is. Does he really seem like a crackhead to you? Or does he seem like somebody who's a little bit slow, maybe because of the beating, that's doing the best he can in life? He wants to say, well, Inkster's infested with boogeymen and thieves and robbers and murderers, and any cop there should be beating on any motorist that doesn't do just what they want when they want. That can't be so. That can't be so. How does he attack? Well, he's got Mr. Zielinski. Yes, I agree that racists can tell the truth, but that's not the point. The point is, he's got a dog in this fight. He wants to be his friend. He wants to be brought into the circle. So he's a partisan for him. And he doesn't care about people that he thinks are less than him. And that makes a difference in how you look at his testimony. Part of the vehicle to get this before you, his defense, was to ask a lot of police officers on the stand, what would a reasonable officer do? What would a reasonable officer do? What would a reasonable officer do? Well, he had two officers on the stand, and both of them said they wouldn't do that. Right, so he else both said they wouldn't do that. The judge is going to instruct you at the end of the case and follow her instructions. She gives you the law, I just argue for you. And she's going to instruct you about reasonable doubt. Follow her instruction, not what I say. But I think when you distill it down, what you're really talking about is in your heart and heart, soul of soul. Do you believe he's guilty? And if you do, it's based on what you heard here in court. From the first time you saw this video, you knew this was wrong. And nothing's changed. Nothing's changed. I'm confident that you'll do as the judge instructs you. And you'll conclude at the end of the day, based on your reason and common sense, that this was an abuse of power. Because it was not reasonable. I'll show you a brief clip, and then we'll finish it.
Why do you think of me like this? I didn't do like this. I didn't do nothing like this. You think of me like this?
Why did they beat on him like that? Why did he beat on him like that? There's no reason other than he thought he could do it and get away with it. And celebrate. But he can't. And we trust you to say that to you in your verdict. Thank you.
Your Honor, may we vote for a second, please?
No,
I have an objection. I want to make a record.
no.
All right.
I said no.
I hear it.
The arguments are concluded in this particular matter. I'm going to now send you on a break. I'll see you back here promptly at 2 o'clock. At 2 o'clock. You will bring your books. Those books will be the books that I will read from, and after that we'll dismiss for jurors, and you begin your deliberation. All right. Turn to the vote. I am going to let you deliberate. Turn to the vote. All right, here we go. Come back out. Wait.
Back out, back out.
Okay, whatever. Be seated. I'm going to give you an instruction that basically says that the closing arguments are just what the lawyers believe. I've told you in the beginning, I've told you during the trial, and I'm going to instruct you. The law you are to follow is not based on emotion or passion. Heart to heart, what does the evidence say in this particular matter? I will give you the law, and you will decide. You will decide based on the facts and evidence presented and the law that I give you. The remark about in your heart of hearts is to be disregarded, however, counsel did indicate based on the evidence. But I have to tell you that. As I indicated to you before in my selection process, and I will reiterate it to you now, you are a technician. You are to apply the facts, the evidence, to the elements, and then you will determine, based only upon the law and the facts that have been given to you, whether or not the people have met their burden beyond a reasonable doubt as to each and every other. All right, I'll see you back at 2. See you back at 2.